I'm back for another edition of PFTPM, and I know I said just 3 days ago I would only be doing these on an emergency basis. This isn't really an emergency. However, sometimes during the season when there's, football things to talk about, I don't have time during PFT Live, or really, I don't want to subject the co-host to my legal meanderings. There was development yesterday, and based upon our traffic numbers, which I can track in real time, a lot of you are interested in the latest as it relates to the Jon Gruden lawsuit against the NFL and Commissioner Roger Goodell. Coincidentally, not ironically. Many would say ironically here. There's nothing ironic about it. It's fully coincidental. Coincidentally, 3 years ago today, Jon Gruden stepped aside as head coach of the Raiders under duress. Where did the duress come from? Well, it happened on a Monday. On Friday, someone leaked to the Wall Street Journal an email that he had sent to former Washington president and GM Bruce Allen some 11 years earlier, 10 years earlier, something like that. It caused a ruckus, as it should have. It did not cause Gruden to step aside from his job. He coached on Sunday. Then on Monday, someone leaked more emails that Gruden had sent to Bruce Allen, to the New York Times, and that was that for Jon Gruden. Now, these documents came from a supposedly secret stash of 650,000 items that were uncovered as part of the investigation of the Washington franchise and Daniel Snyder. They were supposedly secret, confidential, not to be used. And my big concern was, even though the content of the emails would suggest that Gruden deserved what he got and got what he deserved, someone was weaponizing those documents and weaponizing them in a specific way at a specific time that took out the Raiders head coach several weeks into the season, undermining the integrity of the season. Because they had those emails, I'm told, in June. They could have activated whatever was activated to get Gruden out then, giving the Raiders a fair chance to find a replacement, or they could have just waited until after the season and dealt with it then. Somebody took it upon themselves, himself, herself, multiple people we don't know, and that's an important point here. Somebody decided, hey, here's what I'm going to do. I got access to these emails. I know about these emails. I'm going to leak them to respected publications, Wall Street Journal, New York Times, and the end result is going to be Gruden will be out of a job. That's why he filed a lawsuit roughly a month after leaving his job as the Raiders. And it's difficult to separate the two because you see the emails, and at one point I think like all of them were released. You look at it and you say, okay, I get it. I understand why he can no longer be the head coach of the Raiders. But the fact that someone, by all appearances, again, more on that in a second, deliberately and intentionally used those to target a guy to get him out of his spot during a season. That's what makes it particularly insidious because it affected a team. It affected a fan base. It affected futures wagers that might have been placed on the Raiders winning the Super Bowl. Who knows what they would have done if Gruden had been there. They made it to the wild card round and gave the Bengals everything they could handle, and the Bengals made it to the Super Bowl. So we don't know. We don't know because the possibility was snuffed out when Gruden was forced out. This is all relevant today because yesterday, the Nevada Supreme Court decided to grant what's essentially a Hail Mary pass by Gruden. Gruden, and here's the summary, and it's amazing to think it's taken 3 years to get here. The wheels of justice sometimes don't move at all in the grand scheme of things. He filed his lawsuit, and the NFL does what it always does when it has any reasonable argument to make, or unreasonable as the case may be. The NFL tries to force the case out of court and into arbitration. Why does the NFL like arbitration? Well, most big companies like arbitration because, number one, they don't want to deal with a jury, because a jury is far more likely than an arbitrator to get, I don't want to say confused, but if you watch cases that are on TV or if you hear about different things with jury instructions and whatnot, it can get very confusing. The antitrust case against the NFL this summer, the jury instructions were extremely confusing. To me, as somebody who practiced law, I couldn't imagine as a layperson trying to understand them. At the end of the day, the jury is guided by a visceral sense of right and wrong. And if they like the plaintiff and they don't particularly care for what the defendant did, the big, bad, nameless, faceless corporation, it's very easy to play Robin Hood and rob from the rich and give to the poor. And that's what big companies try to avoid. They don't want to face a jury because they end up tripping into a Robin Hood mentality. Beyond that, I mean, yeah, you'd like to rig victory, so you push it to arbitration where it's one person, a retired judge, a lawyer who does a lot of those cases. You don't get caught up in the emotions. The person's more likely to understand the law. The decision is going to be well rooted in facts and law. That's why big companies like to get as many cases filed against it as possible to arbitration. And we've seen over the past 25 years really a proliferation of companies adding in fine print on the back of consumer contracts, employment contracts. You know, when you show up for your first day on the job and they give you all those forms to sign, are you going to say no? What are you going to say? You want the job. Sign whatever gets put in front of me. I want this job. That's how it happens. And then when things go sideways, your door to the courthouse is locked shut. There's been a lot of litigation over the limits of how far that can go, but that's what this litigation is about now. How far can the NFL go? Not just in forcing arbitration, but also in setting up a system where it isn't some independent party that determines the outcome, but it's the commissioner or the person the commissioner handpicks to be the arbitrator. That's what Gruden's fighting. That's what they've been fighting for 3 years. Now, I was going to say in a nutshell, but it's a pretty big nutshell. But I'm trying to make sure everybody understands where we are. So, Gruden files his lawsuit. The NFL files a motion to dismiss the case and compel arbitration or whatever the specific word is, but that's the end result. No lawsuit, go to arbitration. The NFL loses that at the trial court level. The basic low level, here's where you file the lawsuit. There's a judge assigned. They handle the case start to finish. That judge says no arbitration. And I'm not going to get into the niceties of the argument as to why the NFL wants arbitration. It's not from Gruden's contract. It's from the Constitution and bylaws. There's language in there that I personally think doesn't apply and shouldn't compel Jon Gruden to take his dispute to arbitration. The trial judge agreed with me. Then what happened? The NFL exercised its right to appeal that decision to the Nevada Supreme Court. Now, here's how it works in Nevada. There isn't an intermediate appellate court. It's one court, Supreme Court, and there's 7 judges or justices, if we're going to be appropriately respectful of the position. 3 of them get randomly assigned to the case. Of the 3, 2 voted for the NFL, 1 voted for Gruden. End result, NFL wins. Case must go into arbitration, where it won't be a jury. It'll be private. That's another important factor here. We don't find out anything. The discovery process, which can be very meaningful as it relates to shining a light on things that people might not want that light to be shined upon, that doesn't happen in arbitration. And it's the commissioner or his designee resolving the case. And there's enough of a conflict of interest when the commissioner or his hand-picked designee is handling an arbitration involving a claim against one of the teams that hired and continue to employ and pay Roger Goodell many millions per year. There's already a conflict there, a conflict he shouldn't even want. He shouldn't want to be in that spot where it's like, well, I kind of see this person's point, but these are the ones who pay me. Like, why do I want to put myself in that position? In this case, the claim is against the league and Goodell himself. I was baffled that the Nevada Supreme Court voted 2-1 to force arbitration. And it felt like Jon Gruden was out of options, unless he's going to go to the U.S. Supreme Court. And without risking getting what many will say political, it's not political, it's reality. The current composition of the Supreme Court is such that good luck trying to advocate for the rights of the individual against a major business/corporation. So there was still one more opportunity for Gruden. And it's called a petition for rehearing en banc, which is, and like these weird little Latin words just pop up from time to time when you practice law. Not all the time. It's not like the old Latin mass that they did in the Catholic Church. Just every once in a while, there's some fancy little Latin phrase, en banc, which means everybody. All 7 justices of the Nevada Supreme Court should hear this case. That was the request Gruden made. And you have the right to do it. Most of the time, it doesn't work. But this time it did. That was the ruling yesterday. The Nevada Supreme Court decided that it will take up the case with all 7 justices. Now, the one-page order cites a rule that says if any 2 or more of the justices want to do it, that's enough to have a rehearing. So it's possible that those are the only 2 that are partial to Gruden here, and the other 5 are going to be partial to the NFL. We don't know that. But it takes 4 out of 7 to win the case. And, I mean, I look at it this way. If I'm one of the 2, and if I fear I'm the only 2 who are in favor of this thing not going to arbitration, force the other 5 to write an opinion that gets put out publicly that actually makes sense, that actually holds water. Put your name on that. The idea that you're going to allow the commissioner of the NFL or his handpicked designee to arbitrate a case involving claims against the commissioner, against the league. It just shouldn't happen. And the big reason why, and I'm probably going to get a call or somebody at NBC is going to get a call, but the big reason why we should all be rooting for Gruden here, and you have to compartmentalize, you have to set aside the emails, because he could be anybody. The reason we should be rooting for the cause that, how about that? The cause that Gruden is advancing. We're otherwise not going to know who ordered the code red. We're not going to know who did what they did, why they did it. We're not going to know how those documents came to light. If this thing goes to court, we're going to find out. If it goes through the discovery process, Gruden's lawyers will have the ability to take depositions, request documents, emails, text messages, and we'll have a chance to put the puzzle together that will lead to whoever it was that gave the materials to the Wall Street Journal and then the New York Times. Now, obviously, you can't subpoena the reporters. Well, you can, but they're not going to tell you who their sources are. But there should be enough evidence available from the NFL, from the Washington Commanders, from others in the league structure who were involved in this effort to collect and harvest and disseminate and understand those emails. There'll be plenty of digital footprints out there. And if it stays in litigation, we will find out. If it goes to arbitration, I guarantee you that thing gets resolved before Gruden ever gets a chance to find out who it was that leaked those materials. And it'd be a very easy resolution. Gruden's behavior prevents any claim that he could ever make over how and why his separation from employment came to be. Bang the gavel and everybody goes home. I think that's what would happen in arbitration. In open court, not so fast. In open court, we'll find out. And we should all want to find out again because somebody undermined the integrity of a season. If we're going to worry about the integrity of the game, we need to worry about the integrity of, at the time, was it still 16? All 256 games? If it wasn't, it was 272. I think 2021 was the last year of 16 games. So we should want Gruden to prevail. Now, I say that with one caveat. And there was a comment or a report or whatever. I think it was a long read from ESPN.com about Gruden, June or July of 2023. The quote in there that got a lot of people to read our story at PFT and my analysis of where things stand and where things can go. Gruden intends to burn the NFL's house down. Now, I don't know that he will, but if he's got that attitude, if it's truly not about the money, if there's truly no amount of money that they can put in front of him to get him to settle the case, then he will find out, and we will find out. But there's always a chance, and we saw this earlier in the week with Jim Trotter, and I am in no way faulting him. He was able to do very good things with whatever the NFL paid, and my guess is the NFL paid a lot to get Jim Trotter to say, hey, I can create scholarships. The NFL is going to contribute to the scholarship fund. I can do a lot of good things with this. I'm willing to set aside my desire to expose the NFL, to force them to put evidence out there that will cause people to realize the things they do. I'll sacrifice that because I'm able to do a lot of good with it. With Gruden, I mean, unless there's some charity he sees an opportunity to dramatically support with however many millions the NFL would pay him to avoid having to surrender the information that will let everyone know who it was that leaked that information. Without that, that's going to be the question. Because once they're boxed in, that's when the money is going to start coming out of the bottom of the slot machine for Jon Gruden. Will he say, I don't want it? I want to find out the truth. We owe it, after having come this far, to anyone who cares about the Raiders and cares about justice and right and wrong, to find out who it was that deliberately picked up a couple of pages and sent them to the Wall Street Journal and then more to the New York Times with the clear goal of taking out Jon Gruden during a football season. So here's where it stands. The rehearing is going to happen. Now, if the NFL loses, I guarantee you they're going to take it to the U.S. Supreme Court. They did the same thing when they tried to cobble together some cockamamie argument in St. Louis as to why the claims made against the league after the relocation of the Rams should go to arbitration. So we could be looking at 2 or 3 more years, but the point is this. The case felt dead. It's now very much alive. And if and when Jon Gruden gets a chance, while he has that tiger by the tail, to hold on tight, I hope he does. And I hope he doesn't give in. And I hope he doesn't say yes, because there's a mystery that's still lingering that many aren't paying attention to. If we get to a chance where we can start to solve that mystery, it's going to be a pretty big deal. And whoever it was that leaked those emails, and there weren't many people that had access to them, that person's going to have some explaining to do if and when the truth ever comes out. Hi, it's Mike Florio. Thanks for watching PFT on YouTube. Hit subscribe for the latest news and analysis from Pro Football Talk.